There is a piece of advice going round that sounds clever and costs people the chance to act. It goes like this. The notice that comes through your door is only a photocopy. It has no wet signature, no judge has signed it, so it is not real and you can ignore it. Every part of that is wrong, and believing it is one of the fastest ways to lose the one window you have to actually do something. So today we are going to answer the question plainly. Does an eviction notice need a judge's signature? Then we are going to show you what does matter on that paper, because there is a real checklist, and almost nobody points a camera at it. This is England and Wales. Nothing here is legal advice about your own case. It is about what the rules require of everyone. The whole problem comes from treating 3 different pieces of paper as if they were one. So let us separate them, because once you see them apart, most of the confusion falls away. The first is the possession order. This is the judicial decision. A judge looked at the claim, applied the law, and decided the claimant was entitled to possession. This is where a judge actually considers your case. It is the only one of the 3 that records a judge's decision. The second is the warrant of possession. This is the court's authority to the bailiff to enforce that order. It is issued through the court office on request. The rules do not require you, the occupier, to be served with the warrant. What you receive is the notice of eviction. The third is the notice of eviction. This is the bailiff's advance warning, telling you when the eviction will happen. It is Form N54 for the first notice, and Form N54A for any further notice. This is the paper that comes through the letterbox. It is an administrative notice. It is not the order, and it is not the warrant. Remember those 3: order, warrant, notice. 3 documents, 3 jobs. The advice that gets people into trouble applies order logic to a notice and expects a judge's hand on a piece of paper that was never designed to carry one. Does the notice of eviction need a judge's handwritten signature? No. It is an administrative notice from the bailiff. The specimen form has no judicial signature block on it at all. There is nowhere for a judge to sign because no judge is meant to. Does the warrant of possession need a judge's handwritten signature? Also no. Nothing in the rules governing warrants imposes one. And where the rules do require a signature on a court document, a signature printed by computer or by other mechanical means satisfies that requirement. So even the search for a wet signature is looking for something the rules do not ask for. What about the seal? The claim that it needs an original seal and that a printed or copied one is fake. 2 answers, and the second is the stronger one. First, where the rules require a document to be sealed, that seal may be applied by hand, by printing or electronically, and a document that appears to bear the court seal is admissible without further proof. A printed seal is a valid seal. Second, and this is the part that ends the argument, nothing requires the notice of eviction to carry a seal in the first place. So the photocopied seal objection fails twice over. The printed seal would be valid, and the notice never needed one. And being a photocopy, there is no rule that a copy is invalid. The notice is meant to be delivered to you as a notice. A copy is exactly what you are supposed to receive. Here is the part that really matters. The myth says, look at the signature. The law says, look at the identifiers. So when a notice lands, this is the checklist that matters. Not the signature. This, the name of the court, and whether that court is the one that made the order. The claim number, the warrant or writ number, the names of the parties, the property address, and the stage you are at, because possession claim, possession order, warrant, and notice of eviction are 4 different moments, and they are not interchangeable. Then the eviction date and time, and whether the required notice period was actually given. Notice what is not on that list. A signature. And there is one item on it that is the single most useful thing in this whole episode. If the name, the address, the claim number, or the court on that paperwork does not match, that is a real reason to contact the issuing court at once. It might be a clerical error. It might be the wrong property. The proceedings might relate to someone else entirely. You do not argue that at the bailiff. You check it with the court that issued it, and you do it straight away. That is the difference between the myth and the method. The myth hands you a reason to do nothing. The method hands you something to check. Say something genuinely looks wrong. What is the real route? The notice itself points you to it. The form to use is the N244, and you make that application to the court that issued the warrant. On an N244, you can apply to suspend or stay execution of the warrant, apply to set aside or vary the possession order, or apply to set aside the warrant. How much room the court has to help depends on the type of order. Where the order was made on discretionary grounds, the court has wide power to suspend. Where it was made on mandatory grounds, that power is very limited. In a mortgage case, the court's power comes from Section 36 of the Administration of Justice Act 1970, which lets it stay or suspend where the borrower is likely to be able to pay within a reasonable period. And if the fee is a barrier, help with fees can cover it. There is one more real step that people get half right. If the eviction did not fully take place on the day stated, a further notice on Form N54A must, as a general rule, be delivered at least 7 days before another attempt. So a missed attempt does not restart the whole process, and it does not kill the warrant, which normally remains valid for 12 months from issue. But it does trigger that fresh notice period. There are narrow exceptions where the court can dispense with or vary that, and it works differently for warrants against trespassers. But the general rule is the 7-day further notice, and the timing point sits over all of it. Most of these powers depend on acting before the eviction is carried out. If a further notice has not arrived and another attempt is being made, that is a point to put to the court now, while the remedies still exist. 3 beliefs from this world of advice do real damage, so let us name them. First, that an unsigned or photocopied notice can be safely ignored. Act on that, and you do nothing until the bailiff is at the door, by which point almost every remedy has already gone. Second, that arguing with the court office is a substitute for a proper application. It is not. The office cannot rule on your case, and the clock keeps running while you argue. Third, that putting the property in a trust or claiming authority over a trust defeats the order. It does not. Placing a property in trust does not defeat a registered charge or suspend a possession order, and authority over a trust does not make you a party to the case or entitle you to case information. Courts have struck out claims of that family as an abuse of process, with costs. The pattern behind all 3 is the same. These arguments do not just fail, they burn the exact window in which a real application could have been made. So, does an eviction notice need a judge's signature? No. And chasing that question is how people miss the ones that count. The order is where the judge decides. The warrant is the bailiff's authority. The notice is your warning. Check the court, the claim number, the parties, the address, and the stage. If something does not match, contact the issuing court at once. If you have a genuine issue, the route is an N244 to that court, and the time to use it is now, not on the day. Look at what the paper is, not at whether it is signed. That is the check that holds up. Everything else is noise that runs down your clock.